Hey, how you doing? It's Politics with Laura. How are you doing? Well, there is a lot going on down there in Georgia. A whole lot. And I'm getting ready to patch into the trial. Oh my goodness. Now, if this happens, then that means that excuse me. Then that means that Trump can have Fani Willis deposed or disqualified. Boop, boop, boot her off. Sure, he has enough problems already to begin with, but that right there is a little bit beyond the, oh my goodness. I'm sorry. Beyond everything that's going on. Okay, there it is. All right. Okay, I'm sorry. I'm just trying to get everything together. Okay, that looks good. Okay, good. All right. All right, it looks good. It looks good. Okay. All right, let's go ahead and get to it. Okay, it's just starting. Let me move it up just a little bit.
Now, if we look on the interrogatory that I believe, as we indicated, there's really, I think, on page 2, the one that starts off, describe each instance in which you've had sexual relations. You see that one?
Yes, sir.
All right. Now, that interrogatory begins, describe each instance in which you have had sexual relations with a person other than your spouse during the course of the marriage, including...
I'm sorry, they're getting straight into it. I thought that they were going to just go around that. Nah, they're going, you were doing a bad baby with Fani. Oh my goodness.
The period of separation. You see that?
Yes, sir.
Now, these were filed on May the 30th, 2023, correct?
Yes, sir.
Now, at that time, you had had sexual relations with Miss Willis, correct?
Well,
Your Honor, I'm going to object to the question as raised. I think the question is properly, at that time, certainly asked about his answer, but I object to...
All right, Mr. Gill, I just ask you to rephrase, but I think you can make the same point.
Well, Your Honor, it's a specific interrogatory, and I would, so the words do matter.
And I would like him to answer whether or not he'd had sexual relations with Miss Willis, because if he answered yes, then this interrogatory is
right. There's Nathan Wade.
Is a false interrogatory.
He's the one
So
that
I
did the
would
bad
ask
baby
the
with.
court's indulgence. I'm not here to jump into some salacious bedroom situation.
I'm sorry. Yes, you were getting ready to get into that salacious bedroom situation, but right there's Nathan Wade. He's the one that was the special prosecutor that Fani Willis hired while she paid him $650,000 while they had a sexual relationship. And, ooh, it's going to get real something. It's going to get real.
But this is an interrogatory that matters, so I would ask the court's indulgence.
Ms. Cross.
These questions have been asked and answered several times. I understand Mr. Gillen is coming at it from a different way, but this question is not substantively different than those that have already been asked and answered in the information that he's seeking.
All right, Mr. Gill, I'll allow maybe this question and one more, but I think you are asking it in a different way, and I'll ask you to stick to the point.
Right. Now, as of May the 30th, and may I ask the question that I, okay, thank you, Your Honor. As of May the 30th, 2023, you had had sexual relations with Miss Willis, isn't that correct?
The interrogatory, sir, asks during the course of the marriage and the period of separation.
Excuse me.
My response,
Your Honor, I would ask the court to direct the witness to answer my question, yes or no. As of May the 30th, 2023, had you had sexual relations with Miss Willis? Yes or no?
Mr. Gillen, let's start with, at the higher level, whether he believes he answered it truthfully.
I'm sorry, he's getting all up in it. Did you have with Fani Willis? Answer the question, did you? I'm sorry. I watched too much Matlock.
We can drill down into why or why not he doesn't, and maybe we'll end up exactly where you left us.
Well, but again, Your Honor, the point of it is that the words matter, and that we have to establish what did and did not happen, and then he can give whatever explanation he chooses to what apparently is a false answer. But I would like an answer to my question.
And you may get one. I would like us to start at the high level before we drill down into specifics to see whether he actually contradicted that in interrogatory, if I'm making sense.
Well, the interrogatory is relatively direct and explicit.
Sexual relationships with a person other than your spouse during the course of the marriage, including the period of separation. That's pretty simple.
Sure. Let's see if that's something you can get him to admit.
You did have sexual relationships with someone other than your spouse during the course of the marriage and during the period of separation, which included up to May the 30th, 2023. Isn't that correct, sir?
My answer to this interrogatory is none. Is no.
So you're saying that you did not have sexual relations?
Oh, wait a minute. Wait. Hold on. Fanny admitted to having a sexual relationship with him, but now he's saying, according to that right there, no. Oh my goodness. It's going to get crazy.
Relationships with anyone outside of your marriage, and the period of separation is during the period, then you're answering the question to this interrogatory, correct, sir?
I'm saying during the course of my marriage, I did not have sexual relations to anyone, and this answer's no.
Well, again, Your Honor,
I understand. You can proceed, Mr. Gill.
We need a yes or no. Let's just get down to it. Did you or did you not, by May the 30th, 2023, have had sexual relations with Miss Willis, yes or no? Yes or no?
Yes.
Okay. Now, what you did is you answered no to that question, didn't you, or none, correct?
I didn't answer no to the question you just asked. I answered no to the interrogatory question.
And the interrogatory stands that you answered as a pleading in a civil proceeding, your divorce case, right?
Yes.
Now, excuse me. The next interrogatory, let's move there. That interrogatory states as follows: identify any and all occasions in which you entertain a member of the opposite sex other than your spouse who is not related to you by blood or marriage. You see that?
I do.
Now, there are two parts to this. The second part is, I read on, or in which a member of the opposite sex other than your spouse, not related to you by blood or marriage, entertained you. And then it goes on to say, including but not limited to dining, drinking, in restaurants, bars, pubs, hotels. You see that, correct?
I do.
Now, as of May the 30th, 2023, when you filed this interrogatory, you had in fact entertained Miss Willis on many occasions, had you not?
Again, during the course of the marriage was irretrievably broken in 2015.
Well,
the answer's still no.
Let's read what the interrogatory says about the time period required to answer the interrogatory. Because what it says is, it goes on to say, including but not limited to dining and or drinking at any restaurants, bars, pubs, hotels, or persons' homes from the date of marriage to the present. You understand what the word present means?
I do.
Okay, look, okay. Mr. Wade is saying that his marriage was broken in 2015. He never got a divorce. He just simply up and said, okay, I'm going to go ahead and go leave my wife by because his wife is no saint. Ooh, okay. So what this lawyer is doing or prosecutor is doing is saying, hey, you're not divorced. Were you and Fanny doing a bad baby up to 2023? Okay. I'm sorry, I don't mean to interrupt.
And present means the filing on May the 30th, 2023. Isn't that right?
It is.
So as of May the 30th, 2023, you had done a lot of entertaining
of Miss Willis, had you not?
I had done some, yes.
And in fact, under your testimony, you would have said that she had also entertained you. Isn't that correct?
Yes.
And so your answer to this interrogatory is false, is it not, sir?
No, it's not false.
Well, hate to dance around the. The answer is yes, you did entertain Miss Willis, correct? Right?
Yes.
She's not your spouse at that time or at any time, correct?
That's correct.
She's not related to you by blood or marriage, correct?
That's correct.
But you entertained her, right?
Yes.
And during the course from your marriage, the period of time up to the present, so the answer would have been, yes, I did entertain somebody, correct?
During the course of the marriage, no.
Mr. Wade.
Mr. Gillen, I think we've made our point. I think it speaks for itself, and we can save that for argument.
I'll just follow up with one quick question.
You can't get out of that
understand
legality.
What the word present means?
Your Honor, that's what I asked him.
I think we did cover that already as well.
Okay. Now, what has happened from the time that you filed this court document in May of 2023, let's go over some of the things that you had been involved in terms of being entertained or entertaining. Prior to your filing on the answer on the interrogatories on May the 30th, 2023, we've already established, have we not, that you had paid for a Royal Caribbean cruise to the Bahamas with Miss Willis, correct?
Yes, sir, with Miss Willis and my mother.
Well, your mother's not part of this interrogatory. I'm talking about Miss Willis, okay? So
He said any
you
woman.
paid and caused to be paid approximately $3,335 on that trip, Bahamas trip, from October the 28th through October the 31st, correct?
Your Honor, objection. I think we've touched this ground several times already.
Mr. Gillen, let's cover new ground.
Well, I'm just trying to establish with specificity the things that he had done to entertain.
Or be entertained prior to May the 30th, 2023. I'll try to move through it.
Sure. Well, that's already part of the record.
In terms of his prior testimony, and so if you want to link those two things together, you can do that during argument.
Well, so let me discuss this. You indicated that during the course of your explanation concerning the Belize trip, that Miss Willis paid you all that money back in cash. Remember?
Yes, sir.
Now, the Belize trip had just happened, hadn't it? That occurred in March 18th, 2023, right?
Yes, sir.
So you're filing this maybe 2 months after you have gone to Belize with Miss Willis, correct?
Your Honor, again, I believe all of this is our.
I think you might be getting somewhere new. We'll see.
All right.
Yes, sir.
So we've got the trip in to Belize on March the 18th, 2023. You and Miss Willis, correct?
Yes, sir.
Now, 2 months later, you file the interrogatories that speak for themselves that we've gone over a few minutes ago, correct?
Yes, sir.
Now, the March the 18th, 2023, to state the obvious, is before May the 30th, 2023. Will you agree with me on that?
I do.
Okay. So then you tell us that Miss Willis paid you in cash all the money for the entire trip. It was a gift for you for your birthday, correct?
Yes, sir.
And I'm sure you probably have the deposit slips where you took the cash and deposited the cash into your account, don't you?
I did not deposit the cash in my account.
You don't have a single
he caught you.
solitary deposit slip to corroborate or support any of your allegations that you were paid by.
Come on now. No, you didn't. Look, you know you didn't. You took her on a vacation and you're saying that she paid. No, look, that's a lie. That's a lie.
By Mrs. Willis in cash, do you?
No, sir.
Not a single solitary one.
Not a one.
Now, when Miss Willis would pay you in cash, would you scamper down to the ATM with her and as she drew money out of her account
Your
to
Honor.
pay you these thousands of dollars?
Mr. Gillen might scamper, but there's been no evidence that Mr. Wade does. I object to the phrasing, the argumentative nature of the question.
All right, on that issue, overruled.
No.
Did you and Ms. Wade scamper down to the ATM machine and have her dry out? For example, on the Belize trip, just on your payment would have been $2,794.
Miss Wade,
For clarity, yeah, thank you.
Pardon me?
Miss Wade and I didn't go to Belize.
No, excuse me, Ms. Willis. I'm sorry. Did you go down to the ATM with Ms. Willis while she drew out $2,794 to pay you in cash? Did you go to the ATM with her?
No, sir. She didn't go to the ATM. She carried the cash.
Oh, and so she would give you the cash. Did you have a little place in your house where you just stack up all this cash that you apparently got to repay you for these benefits that you bestowed on her?
Now, Mr. Gillen, if I answered that, I'm putting myself in jeopardy. If I tell the world that I have cash someplace in my home, don't you think that could be problematic?
No, I don't. I want an answer.
He's slick. Oh my goodness, he's slick. Oh man, look, I get why Fanny likes him. I get it. I get it.
Answer as to whether or not you have a little cash hoard in your house where you have allegedly taken the money that you got from Mrs. Willis and went and put it somewhere. Where'd you put it?
No, sir.
Now, just put it on the hip and kind of walk around money?
Did I put it on my hip?
Yeah, just walking around money where you would spend cash yourself?
Let me finish. Did I put it on my hip in Belize and walk around with
No,
it?
when you got paid back, would you take the money, the cash that she gave you, and would you just carry it around with you for spending money around town?
So we have to break down each trip because, for example, for the cruise, she paid me the money before we took the cruise. So I was here and I could put the money in my pocket or put it away wherever I wanted to do with it. Other trips, she would give me the money there. So at that point, I could either spend it or put it in my pocket or put it in the hotel safe.
There's no special place that you would have all this cash that you would be getting from her that you've told us about to pay back for the benefits that you have bestowed on her?
The only special place that cash would have gone would have been to one of my children.
Okay. Now, are you aware, have you discussed these pleadings with Ms. Willis?
So the time, I don't believe that's an accurate reflection of the
He's not going to
testimony.
admit to that.
That's an appropriate question.
I think overruled. You can answer the question.
Okay. When you said proceedings, are you talking about the divorce proceedings? Because we were talking about the interrogatories. To that
No.
question, the answer is no. If you're go ahead.
I'm sorry. Go ahead with your answer. I'll hear the complete answer, then I'll follow up.
Okay. If you're asking me about this hearing, the proceedings of this hearing, have we discussed the financial piece based upon Mr. Roman's motion? Yes.
So you have discussed the financial piece. Where did that discussion take place?
Conference room.
Were you other people there, or were you and Ms. Willis discussing this about what your position was going to be?
Relevance of this.
Well,
Mr. Gillen?
and the relevance has to do with suddenly we have a declaration from Mr. Wade in this case, where he says roughly equal, and then shows one alleged payment by Ms. Willis. No mention of cash, none. So I need to find out a little bit more about how suddenly we have this revelation about cash from the witness stand.
He tripped him up.
today.
All right, overruled.
He tripped him up. Got him.
So we part company there when you say no mention of cash. If I provided one receipt that didn't amount to what you would think was roughly equal, the rest of it is cash.
Well, did you in your declaration, sir, that was filed in this case, did you tell the court
Is
in
that
that
fair?
declaration that the expenditure that you had provided
That's
on behalf
Fanny.
of Ms. Willis was paid for back by her in cash, yes or no?
I believe that I did when I said that the expenses were split roughly evenly.
If you could point to me any place
There's
in
Fanny
your
back there.
affidavit
She's not supposed to
where
be
you
there.
use the word cash, I would appreciate it. Take your time.
I didn't use the word cash. No, sir.
No, you didn't use the word cash, did you?
But I didn't say that she didn't give it to me in cash.
No, you just didn't tell anybody that you allegedly got paid back in cash, right?
No, I told everyone who asked.
Today.
Yes, sir.
Now, who else was with you, if anyone else, when you and Ms. Willis were discussing how you would be handling the financial component of the motion here today, that is the personal benefits?
I'm sorry. He's going after everyone. Was anyone with you? Was there a complete stranger right next to you saw the exchange? Did any passerbys? Anyone? Wow, they are trying hard. Oh my goodness.
Mr. Gillen.
Well, the relevance is if they know that they're going to be called as witnesses, they've been subpoenaed, and they are discussing what they're going to say, we need to know that. The court needs to know that. It goes to the veracity of Mr. Willis and, Ms. Willis and Mr. Wade.
Overruled.
We didn't discuss how we were going to handle testimony.
My question was, when you were discussing with Ms. Willis in the conference room, when you were discussing what you perceived to be the situation concerning the benefits for the payments,
Yes, sir.
was there anyone else present?
No, sir.
How long did the meeting take?
Probably 5 or 10 minutes.
Did Ms. Willis tell you what she was going to say?
No, sir.
Did you ask her whether she had any bank withdrawals that would corroborate the assertion that she would pay you back in large sums of cash for these trips to
The Caribbean, Belize, California, on and on and on.
Your Honor, again, I object. The proffer, when the last relevant suggestion was made, was that Mr. Dillon needed to know who else was there, these potential witnesses that he could cross-examine. That question has been answered, so I can't object.
Okay. I think it's still exploring possible bias or motive to shape his testimony, so overrule on that ground.
Thank you.
They're trying hard.
Now,
Fanny's in
Mr.
the
Willis,
back.
excuse me, Mr. Wade, when you were having this discussion, did you ask Ms. Willis, do you have anything to support these cash withdrawals?
No, sir.
Did you ask her where she got the cash?
Here, this is the conversation. I produced my credit card statement that showed what Miss Merchant in her filing was representing. Mm-hmm. That was the conversation.
Okay. So when she would pay you back in cash, were you aware of what her financial situation was? Do you know what?
No, sir.
Your Honor, I object to the relevance.
Well, Your Honor, it's relevant because we've been bombarded with a book, Find Me the Votes, in which...
What's at issue is the financial benefit, and if that plays a material interest.
He's trying
in an
hard.
actual
Anything.
conflict of interest, so I think that's relevant.
He's taking noodles and throwing them
Now,
against the wall.
have you read the book, Find Me the Votes?
I have.
You have.
I have.
Okay.
He's trying anything.
Now, in that book, Ms. Willis is telling the authors about how financially destitute she was, or kind of hitting down on the bottom as she was running for DA. Do you remember that part of the book?
So let me qualify the response. I've read the book in parts. I hadn't had the time to sit and read the book in its entirety.
Did you read that part about how she's telling the authors about how little money she had and how financially she was in bad shape prior to when she was running? Did you read that part?
No, sir.
Did you ever have discussions with Ms. Willis about her financial situation, which was in apparently in rough shape prior to her being elected DA?
No, sir. Ms. Willis made it clear that her financial business was just that. It was her business.
No, Wade, you know you're lying. Because if you're with this woman and you all have a serious mutual relationship and you and your wife haven't been together in years since 2015, you simply didn't get a divorce and you're with Fanny and you all are like, right? And you're saying that she never said, hey, honey, you know, I'm doing a little bad and I need some help financially. Whatever.
I know nothing about her financial status. I know nothing about how she was faring before or after the election, or even now. I know nothing about her finances.
Telling us that she didn't share that with you, but chose to share it with the authors of a book that's been published and printed and sold nationally.
I think that's a fair question for Cross.
I don't know that she shared it with the author. I don't know that the author is telling the truth. I don't know the author, so I don't know, sir.
Okay. Now, did you give an interview to the authors of that book?
I've given no interviews, sir.
So you haven't talked to them at all, correct?
I haven't talked to any media.
All right.
None.
Now, as it relates to the...
I'd like to, though.
As it relates to, again, from your bank records that you're aware of, there'll be no cash deposits, right?
I didn't say that.
Are there cash deposits which line up with the money that you have allegedly received from Ms. Willis to quote,
he's
pay you
slippery.
back for her part of the trips?
So here's the thing. In my bank records, you will see cash deposits. You will see check deposits. I can't say that you look through the bank records and you won't see cash deposits, because I have two sources of income, sir. Income comes from my private practice, my firm, and income comes from the contract here with Fulton County. During the course of private practice, occasionally I will have occasion to deposit cash into my account.
And in preparation for this hearing and your testimony, did you go through your bank records to find out if you could locate any cash deposits that would corroborate your testimony?
No, sir. I didn't go through my bank records at all.
Now, so what you would do, the money that you received, of course, the money that you received from your work for Fulton County, that's public funds, correct?
No, sir. That's private funds. It's my
Public funds pay you to do work for Fulton County, correct?
Tell me what the definition of a public fund is.
A public fund would be your funds, as in not fund, but funds, money. Public money, as in money from taxpayers, either in Fulton County or the state of Georgia, pay you to do the work that you're doing here in this case, yes or no?
Okay.
One or the other, I'm certain.
You know which
is
one?
the case. I don't know which one, no, sir.
Now, you would take those public funds, and those public funds were then used, deposited in your account, and they were then used to pay on the credit cards for the trips that you would take with Ms. Willis, correct?
I object to the question insofar as the characterization of public funds. The witness didn't testify to that, and I don't believe there's been any evidence to that. Once it's paid to Mr. Wade, it's private funds.
Well, the point of it is that you got
All
money.
right, Mr. Gillen's rephrasing.
Yeah, I'll rephrase.
They are really trying hard. He's really trying hard to connect him and Fanny and the monies. Now, was the monies coming from Fanny that he said that she allegedly gave him in cash? And then he said he had two streams of income. Now, where is this money coming from? Oh, this guy is trying hard.
Let's break it down. You got money from Fulton County for the work that you do here, right?
Yes, sir.
You would send in invoices, and they would pay you money, correct?
Yes, sir.
Those money, that private money, that money was money from either the citizens of Fulton County or from the state of Georgia, correct? That's what I mean by public funds. Agreed?
Uh-oh.
So I guess I'm having trouble with the notion that the citizens of Fulton County have paid me any funds. I'm not certain the funding source. I can tell you that either the state of Georgia or Fulton County has written me a check.
So that would be, those two entities are public entities, correct?
Yes.
So that would be public funds, right? Right? Yeah.
Yes.
And those public funds are from the same source that you would then use to pay out on your expenses for the trips that you took Miss Willis on, correct?
No, sir. As I testified to moments ago, I have income coming in from my law firm. I also have income coming in from the funds that we're here discussing now from either the state of Georgia or Fulton County and or both. I'm not certain what it is. So
What
to say
Sorry,
that
I didn't mean to
that
cut you off. Go ahead.
So to say that I'm paying a credit card statement with funds coming from Fulton County or the state of Georgia would not be an accurate statement, because the funds could have very well come from my private practice.
What percentage of your income in 2022 came from money where you're working on this case or from your partners working for the Fulton County office?
In 2022, I would say 50-50.
You think 50-50 in 2022?
Yes, sir.
What about 2023?
Probably 60-40.
60-40.
Yes, sir.
So the money that would be in those accounts, at least 60% of those, in your view, would be public funds, that those monies were then used to pay for the expenses that you had incurred for the trips that you took Miss Willis on, the cruises, the Napa Valleys, the Bahamas, correct? Right?
Yes, sir.
Okay. And now, what you did is that when you signed on in November 1st of 2021, that's when you signed on to be counsel for the anti-corruption matters, right?
Yes, sir.
Now, as you know, in your engagement letter, it doesn't say that you're signing on and your scope of work is to work on the Trump special grand jury investigation, does it?
No, sir.
It says that you're signing on to work on anti-corruption, the anti-corruption unit matters, correct?
Yes, sir.
Matters with a plural, correct?
Yes, sir.
So in your contract, there is no specific reference to any specific case. Isn't that right?
That's correct.
Okay. Now, but you didn't sign on for the duration. There was a period, you'd have a contract, and then it would then expire, and then you would have a new contract, correct?
Yes, sir.
Now, of course, the extension that you received, the first one was in November of 2021, and then you filed, there was a renewal in November the 15th of 2022. Is that right?
Sounds right.
Oh, okay. Now, that was right after you got re-upped by Miss Willis, right after you took Miss Willis to Aruba. Isn't that right? On that November the 1st, 2022 trip to Aruba, and through November the 4th, 2022. Correct?
What does re-up mean?
Well, re-up means that you came back, your contract was up, and then on November the 15th, you and Miss Willis signed a new contract for you, right?
Yes, sir.
Okay. Now, when you were in taking her to the Aruba and on the cruises and the resort there, did you discuss your re-upping of signing an extension on your contract?
No, sir. But you make an excellent point. I'm glad you pointed that out. So the trip to Aruba, the contract was not in existence then.
So you're saying that you were not
under contract.
In your contract, did you send any invoices in for work that you did after your first contract expired?
No, sir.
You didn't?
No, sir.
No. When that expired, that was it. So and then you're saying that after the Aruba trip, you get re-upped with a new contract, correct?
I signed a new contract. Yes,
Now,
sir.
was there any modifications on that contract? Did you get an extension on the cap that you were limited on the first one? Were there any modifications at all, Mr. Willis? Excuse me. I've done that again. I apologize.
I've been called worse.
Wait, I'm sorry.
I've been called worse.
Now, were there any modifications on that?
Do you have the contracts in front of you where you could?
I don't have it in front of me, but I think that Birch is going to.
Because I believe as the work gradually, as the time of the work gradually increased, the hourly cap would increase. In other words, starting out the investigation, it was impossible to anticipate the level of cooperation during the course of the investigation from some of the witnesses. So if you assume that there would be great cooperation with the witnesses in terms of interviewing and speaking and being voluntarily speaking with you, it doesn't take as much time. So after getting into it, realizing that most of the witnesses were not willing to speak or willing to turn over evidence or information, quickly you figure out that this is going to take a little more time than originally anticipated. And because of that, you have to compensate for those hours.
That's why there was a compensation on your extension?
Yes, sir. The caps.
A cap. Now, did Ms. Willis review your invoices with you when you would submit them?
Never.
Did anyone ever question whether or not
You worked 24 hours in one day and billed 24 hours in one day.
I've never worked 24 hours in one day and billed 24 hours in one day.
Okay.
And I'm glad you asked me that question because I'd like the opportunity to talk about that.
I think you should go ahead.
So, if you look at that invoice where it says 24 hours in one day, it actually doesn't say one day. If you look at the top of the invoice, it says date completed. The date that's reflected on that invoice reflects the date that the work was completed. It doesn't say when it started. It just says this is the date that is completed. So if you go through the invoices, probably around the first 5 or 6, you'll see that that's the billing format. I would bill only after that particular task has been completed. That's why you see a 24-hour period with the one day there. I kind of wish some of the experts who had opined on that had called me and asked me the question, but there was never a billing of 24 hours in one day. Now, probably around the 6th or 7th invoice, you see the format changed. I started using a range so that it got less confusing, right?
I'm confused, so maybe you can correct it.
Okay.
In Exhibit 14, you've got down a specific day.
Mm-hmm.
Prepared cases for pretrial, November the 5th, 2021, 24 hours at $250 an hour, 6,000. Now, this wasn't about a range. It was about the work that you did on November the 5th, 2021.
No, Mr. Gillen, look at the top of the invoice where it says date completed.
What I want you to do, Mr. Wade, is focus on the date that you have down there and tell the court what you billed for on November the 5th, 2021. I thought it was already in. I thought 14 is in.
Again, Mr. Gillen, it says completed date completed. The dates that you see here are the dates that work was completed. So on November the 5th, I completed the task of preparing the cases for pretrial. That's the date I completed it.
Just read, if you would. Then my question was, read out loud the entry for November the 5th, 2021, and how many hours you billed that day. Just do that for me, if you would.
I can't do that.
Excuse me, I believe the witness is entitled to answer his question. That certainly wasn't the question that Mr. Dillon asked.
All right, well, the question now is to read a certain entry, so.
Just read into the record, Mr. Wade, on November the 5th, 2021, how many hours did you bill the citizens of Fulton County for on that day?
This guy is
Just
something.
read it out, please.
I completed the task on November 5th, 2021. 24 hours was billed at $250.
He's trying hard. Trump's attorneys are trying hard. And they're fighting back. Oh man, this is a mess.
Now, when you talked about your relationship with Miss Willis, and your testimony is that it began in 2022. Do you remember that testimony?
No, sir. Our relationship began in
Your romantic
2019.
relationship began in 2022?
Yes, sir.
That's
Yes,
your
sir.
testimony?
Yes, sir.
Okay. Now, when you were re-upped on this contract, you had a romantic relationship already established with Miss Willis, yes or no?
In 2022?
You know, when
Yes,
you were
sir.
re-upped on November the 15th, 2022, you had a romantic relationship with Miss Willis.
I signed the second contract. Yes, sir.
Answer my question, please.
I'm not going to use the words re-up.
Signed up on the we re-up or whatever you want to call it, your contract on November the 15th, 2022, you had a romantic relationship already existing with Miss Willis, yes or no?
I signed the contract, the second contract, yes, sir, during the course of a romantic relationship.
Yes or no, you had a romantic relationship with her at the time that you signed up the extension on November the 15th, 2022, yes or no?
The answer to that question is yes.
Thank you. Now,
You just should have said yes.
The special purpose grand jury released a report. Isn't that correct? Correct?
Are you asking me if it's before the work was completed or before the special purpose grand jury actually publicly released the report?
When they
Those are
released
two
the
different.
report. Your relationship with Miss Willis already existed when the special purpose grand jury released its report, correct?
At the time the report was released, yes, sir. But
And-
you understand that the report had the work had been completed prior to the release of the report. You understand that?
And your relationship with Miss Willis, of course, was prior to the indictment in this case, correct?
Yes, sir.
Your Honor, if I may just ask my folks over here whether there's anything I need to clean up on. That's all the questions, Your Honor, I have. Thank you.
Your Honor, I do have a question.
Well, Mr. State, I think we went through.
You know, I had asked you for permission, but he was going to go first on this, and then I was going to follow up. That's the deferment, was to allow him to go first. That's what I thought I had asked for.
All right, with the understanding next time, we're going to keep going in order and skip around the order. All right.
But that's why I brought it up, because I thought that's what.
Okay. All right. Mr. Sato.
It's going to be interesting.
I'm going to try to keep my questions very specific.
Yes, sir.
Okay.
Yes, sir.
And I'm going to also, of course,
Try not to go back into specific questions that have already been asked, okay?
Yes, sir.
When did your relationship with Miss Willis end?
2023.
Can you give us an approximation of, not by date, but by month?
Summer 2023. Forgive me. I'm a man. We don't
Do the date thing. Summer 23, I would say June, maybe.
okay. using the euphemism personal relationship, did you have any personal relationship at all with Miss Willis after the summer of 2023?
I want to make sure that I'm answering your question.
Yes, you did.
Because
Let me rephrase, if I might.
Fannie wasn't letting you
The
go.
way it has been characterized in, for example, the response of the state, and I believe in your affidavit, is there's a difference between a personal relationship and a professional relationship. Correct?
yes, sir.
Okay. I'm not talking about a professional relationship. I'm talking about a personal relationship.
Have you had a personal relationship at all, and you know what I mean by that, after the summer of 2023?
Are you asking me if I had intercourse with the district attorney?
I was trying not to, but I guess if you're going to characterize it as that, the answer would be
The answer would be no.
so. It's been purely professional since the summer of 2023.
So that's where we're having issues.
Okay. You'll have to explain, because I don't know what the issue would be.
No, I will explain to
Thank
you. You say personal. We're very good friends, probably closer than ever because of these attacks. But if you're asking me about specific intercourse, the answer is no.
How about if I took?
No.
During the direct examination,
These lawyers are trying hard, but the thing is this. He wrote a declaration, and by him submitting that declaration or the declaration of truth. So Trump's lawyers have his declaration. And when he ever deviates, well, remember back on the declaration? That noise?
you made a statement, at least I believe I heard it correctly, that you, personal relationship, and now I'm talking about that characterized
The sexual romantic relationship was not a secret. Is that correct?
Wait. If you're asking me if people knew that we were having sex, no, they didn't.
I'm asking you whether the people knew that you were dating.
whether you were romantically involved. You said that it was not a secret.
Oh, it wasn't a secret. It was just private. My mother knew, obviously.
Okay. Did anyone in the district attorney's office that has worked on this case know that you were dating or had a romantic relationship with District Attorney Willis?
I don't know what they knew.
Well, did you tell anyone?
Slippery.
No,
Do you have any knowledge of whether Ms. Willis revealed it to anyone?
I have no clue.
Okay. So as far as you know from personal knowledge, no one in the DA's team knew, correct?
That's correct.
Okay. So if it was a legitimate relationship, is there any particular reason why it was kept secret or private?
It wasn't kept secret. It was kept private.
And the purpose for that was?
It's what we chose to do.
I'm asking you why, though, not just because you chose. Why, if you're dating someone, why keep it private?
So, a few reasons. The first one is, and I want to say this respectfully in the right way.
It ain't your damn
There are
business.
some people who are in the public eye who just don't like it, don't wish to be there. I have tried to have lunch or dinner with her publicly, and I can't count the number of people that would approach the table or would accost us as we're trying to walk into a restaurant and just have lunch or have a meal. It is not secret, it is private. We don't want the world asking questions or interrupting that time. So we weren't trying to keep anything a secret, Mr. Sadai. There's nothing secret or salacious about having a private life. Nothing.
I'm not suggesting that there was. I'm asking the questions. When you went on the various trips that have been outlined by both Mr. Gillen and by Ms. Merchant, did anyone in the district attorney's office know that the two of you were traveling on personal trips together?
To my knowledge, Mr. Sadai, no.
And again, that was for privacy, according to your testimony.
Privacy, yes, sir.
Okay. Did you and Miss Willis go to the Hapeville condo prior to your relationship starting the beginning of 2022?
Prior to having physical contact, prior to having intercourse, did we go to the Hapeville condo?
Again, you keep going to intercourse. I'm trying not to, but fine. The answer to that, my question would be yes. Did you and Miss Willis go to the Hapeville condo prior to what I want to say November 1st of 2021?
Yes.
Okay, and the purpose for going to the Hapeville condo with Miss Willis prior to 2021 would have been what? Or prior to November 1 of 2021?
Could have been any number of things, because at that time...
That's what I'm asking, so tell me.
Yeah, could have been any number of things, because at that time...
she had a friend living in that condo. Miss Yurdy lived in that condo.
Okay. It maybe was my question was poorly worded. Let me try again. Your answer is yes, prior to November 1st of 2021,
You would have gone to the Hapeville condo and been there with Miss Willis, correct?
Yes.
And you would have been there, as you indicated, for many reasons, right?
Yes.
Can you give me, just list a few of the reasons?
Miss Yurdy resided there, went to visit her, maybe went to talk about a document that I received.
You would go to the condo to talk about a document that you received?
Absolutely.
You were doing the bad baby, bad baby, bad baby. That's what you were doing. Oh, man.
Okay, go ahead.
Absolutely.
Any other reasons?
None come to mind.
None come to mind.
No, sir.
and would you say that was frequent? When I say frequent, do you think prior to November 1st of 2021, you were at the condo more than 10 times?
No, sir.
So it'd be less than 10 times?
Yes, sir.
So if phone records were to reflect that you were making phone calls from the same location as the condo before November 1st of 2021, and it was on multiple occasions, the phone records would be wrong?
If phone records reflected that, yes, sir.
They'd be wrong.
They'd be wrong.
Okay. Where did you live during that time period?
Same place I live now.
Which is not in Hapeville, correct?
It is not in Hapeville.
It is north of Atlanta, the city of Atlanta, correct?
It is.
Okay. And any other reasons why you would be in the Hapeville area on multiple occasions prior to November 1st of 2021?
Let's see. The Porsche experience is there.
I'm sorry?
The Porsche experience is there.
Okay, so that would have been one. Any other reason?
Yes, sir. The airport is there.
Airport in Hapeville.
Yes, sir. Delta Airlines is
Okay.
headquartered there. Let's see. Restaurants there.
Okay. If that's your recollection, that's fine. I'm not asking you to try to remember everything, but if that's
okay.
Okay. Did you discuss your affidavit filed in connection with the response with Ms. Willis?
No, sir.
Did you know, personal knowledge, whether Ms. Willis reviewed your affidavit before it was included with the response?
I have no clue.
So as far as you know, personal knowledge, Ms. Willis did not know what you said in the affidavit.
I didn't give it to her.
That's what I said. You have no personal knowledge.
No personal knowledge.
And as far as you know, no one else has told you that she did or didn't.
I hadn't asked anyone.
We've kind of worked this up a little bit, and the numbers could be off. But according to our numbers, $10,000, give or take, would have been reflected on your credit card statements in connection with things of potential benefit to Ms. Willis, okay? I want you just to assume that. Assuming that there was $10,000 that you had on your credit cards, is it your testimony that Ms. Willis paid you back $10,000 in cash? Not asking about...
The characterization of $10,000 for Ms. Willis's travel, I don't believe is an accurate reflection of what the numbers, at least the summary that I've been provided by the defense.
Look, he isn't going to sit there and have sexual relations with her and say, oh, could you please give me my money, please? Give me my cash. Oh, okay, Nate, here's the cash. Here. No. This lawyer's trying. He's trying his best. He looks so foolish.
I think that's joint travel. Is that right, Mr. Sato? I'm sorry.
No, it's not joint travel. But
All I'm trying to understand, I'll rephrase because I don't want to get bogged down on specific numbers. You would have received thousands of dollars in cash from Miss Willis, correct?
Yes, sir.
Okay. And the thousands of dollars in cash from Miss Willis, do you know, I'm not asking you whether she took it out of her pocketbook or she took it out of a suitcase. I'm saying, do you know the source of the cash?
Just that, out of her pocketbook. Yes, sir.
you don't know where she obtained the cash.
I didn't ask her.
And the whole time that she was paying you in cash, you never said, hey, why do you have this amount of cash?
Well, Mr. Sadal, in my practice, people come into my law firm all the time with cash. I never question where they got it.
Yeah, but we're talking not about people that come into your law firm. We're talking about the district attorney of Fulton County, who I'm assuming receives a paycheck. She doesn't get paid in cash.
So, just like you assume, I assume she got it from her paycheck. I don't know.
Okay. But of course, it's already been, and I'm not going to go back into it. You've not seen any records indicating withdrawals of cash from Miss Willis at all.
Why would I ask her?
I didn't
No,
ask.
sir.
All I said is you haven't, right?
No, sir.
Okay. Now, can you explain why you filed for divorce one day after you were hired by Miss Willis? You filed on November 2nd of 2021. You're hired on November 1st of 2021. Why the day after?
You mean one day before? So
You filed for divorce.
Because he got that money, he got tired of his wife, so he can get rid of her and go back to Fanny doing a bad baby. That's why. Okay, I'm done.
Divorce one day after you were hired, right?
okay, I'll answer your question.
Okay, please.
So in 2015, when my wife had the affair, we had a conversation that we would divorce right then. Again, the better practice, at least for my children at the time, was to stay in place until the youngest could
Graduate and matriculate into college. We did that. When she graduated, matriculated into college.
At the time, my wife had moved back and forth to Houston, to Texas. So she's in Texas. We take our child off to college. We come back to Georgia for a brief period of time. Divorce gets filed. She gets served. There we go. Now, the reason that date was selected.
Yes, sir. That's what I asked.
The specific reason that specific date was selected was because she was only in town for a brief.
Your Honor, this is attorney-client privilege. Why he decided to file his...
And why do you have the right to object on his behalf for attorney-client privilege?
Because...
Well, I don't make a formal objection.
All right, there we go. And...
I believe that he's already attempted to answer this question, and there was no privilege raised. So he's given a partial answer, and now he's about to finish that. So, first of all, I don't think it's covered by attorney-client privilege, and I'll deal with that if you want me to. But otherwise, he's already answered part of it. So he doesn't get to say, now I'm going to stop. So,
Well, it was a long preface, but I don't think it ever actually got to what might have been at issue there. So if you can lay the foundation, we'll deal with the objection.
okay. Take a step back. Okay. You realize that an attorney-client privilege is the privilege of the client, correct?
Yes, sir.
And you,
In connection with your representation, at least it's been proffered to the court by Mr. Bradley, that it's up to you to decide whether you want to
raise the privilege, right?
Yes, sir.
It's not up to Mr. Bradley.
Yes, sir.
So you have the power, in order to get to the truth of the matter, you have the power to waive the attorney-client privilege, do you not?
I believe that's an appropriate question. privilege is there.
Whether he uses it or not, it doesn't matter why. Mr. Sadow, I think if we're trying to get to the answer to your question, let's figure out whether it covers the question you were trying to get to.
And if I may finish, and your position is you have no intention of waiving your attorney-client privilege, correct?
That's correct.
All right, so now, can you answer the question why you waited until November 2nd, the day after you were hired by Ms. Willis, to file for divorce?
I can.
Okay.
So, again, Joycelyn had relocated to Texas, and she had been in Texas for months. She was only here for a brief period of time to drive my daughter's car back with her. And when she came here to do that, I was able to then get her served.
Okay, so your answer as to why you waited until the day after you were hired by Ms. Willis, which would be November 1st, 2021, to file the complaint for the divorce on November 2nd, 2021, your testimony under oath is because your wife was here. But had not been here in October, had not been here in September, had not been here in August of 2021.
She had been in Texas taking care of her ailing mother and
your testimony,
an aging father. So the first opportunity that I had after speaking with my lawyers to take care of that was the date it was filed and served, because she happened to be here. It had nothing to do with, that was purely coincidental, that contract.
I understand it's purely coincidence, your testimony.
Yes, sir. And understand that this was by agreement between she and I, she being my wife and I, that
it's possible
we would divorce when the children matriculated out, and that there would actually have been an agreement attached to the filing. It became apparent that the agreement wasn't going to happen, and things got a little contentious. So that's when the privilege will kick in, and I was forced to do it when I did it.
So if I understood correctly, again, you tell me if I'm wrong, is it your testimony that your wife was not in Atlanta, Georgia, or the metro area throughout October of 2021?
No. In October of 2021, she was back and forth between here and Texas.
So she was, at least on some occasions, in the Atlanta area.
But that was during the time when we were working through the consent agreement that fell through.
Again, I think we're pretty far afield on relevance. The answer to the question about the timing of the divorce filing.
Understood, Ms. Cross. Mr. Sadow, where are we going from here?
We're about to finish this area, since I'm not going to be able to go any further about, if we want to call the X, we'll call the X for that purpose.
Well, we might have to discuss whether that's a collateral issue altogether.
No, I'm just saying if. I didn't say we will, but we'll.
Okay.
All right, so you said that you were aware of the contracts that Mr. Bradley and Mr. Campbell had with the Fulton County District Attorney's Office, correct?
Yes, sir.
And how did you become aware of those?
Just through conversation, they told me.
Conversation with who?
Mr. Bradley and Mr. Campbell.
So you were discussing matters with Mr. Bradley which were not related to attorney-client privilege, correct?
Related to the contracts, yes.
Okay, but you were having conversations that would not, even though, if I understood correctly, Mr. Bradley was your attorney at the time, correct?
At what time?
At the time that Mr. Bradley received his contract from Fulton County, which would have been beginning of January, or in January of 2021, right?
Is that the date of his contract?
Pretty close.
I don't know what the date of his contract was, but if it was after the date of the filing of the divorce, then yeah.
I'm not talking about after the date of the filing of the divorce. It's been represented to the court that you had an attorney-client relationship with Mr. Bradley from 2015 forward.
Yes,
correct?
Sir. Yes, sir. That is correct.
When Mr. Bradley received his contract with Fulton County, that was in 2021, correct?
I don't know.
We can prove that through other evidence. But at the time that Mr. Bradley was doing work for Fulton County, if I understand, you still had an attorney-client privilege, at least you're claiming one, with Mr. Bradley, correct?
Yes.
Okay. So when you talk to Mr. Bradley about matters with his contract in Fulton County, those were not covered by your attorney-client privilege, correct?
They were not.
Okay, and that meant that not all communications with Mr. Bradley were covered by attorney-client privilege, correct?
Well, those certainly weren't.
Well, but my question was, not all communications with Mr. Bradley were covered by, at least as you've been represented to the court, by the attorney-client privilege, correct?
Those communications were not.
So there were communications outside of the attorney-client privilege, correct? With Mr.
Yes.
Bradley.
If you're asking me if I ever communicate with him outside of the attorney-client privilege, the answer is yes.
Okay.
I've communicated with him outside the attorney-client privilege.
Let's finish this up. In, did you call it Roman number 4? Which is defense. Okay. In defense exhibit number 4, and Mr. Gillen went over with you your responses to certain interrogatories on May the 30th, 2023. Remember that?
Yes, sir.
Not going back into those. The words in the interrogatories are already in evidence, so we're not going to do that. But the ones that we've gone into, there were 2 of them. And your answer to both of those was none, correct?
Yes, sir.
Okay. Now, on January 25th of 2024,
Yes, sir.
you again were in a position that you answered those same interrogatories, the 2 that we're talking about.
I can get specific if we need to, but as long as we understand we're talking about the same 2,
Yes,
right?
Sir. Yes, sir.
Okay. And they are in defense exhibit number 6, and they are interrogatories number 4 and number 5.
Okay. Go ahead.
No, I want you to be able to see it. So it's a defense exhibit number 6.
I don't.
See, you have 6 up there. I'm told that you have 6.
Okay. Here we are.
Okay. You would agree with me that in defense exhibit number 6, and we're talking about interrogatories of January 25, 2024,
Yes, sir.
that as to interrogatory number 4, that's the same interrogatory, same words that were in the interrogatory that Mr. Gillen went over, which was dated May 30th of 2023, correct?
Yes, sir.
And your original response in defense exhibit number 6 was none, correct?
Yes, sir.
Your updated response was the plaintiff declines to respond to this interrogatory and asserts his privilege pursuant to OCGA section 24-5-505, correct?
Yes, sir.
You know that 24-5-505 breaks down into two privileges, right?
Which is why I was specific. I said I asserted the privacy privilege.
Well, that's what I'm asking you. But in your updated response, there's no reference to privacy, correct?
Yes, there is in the code section 24-5-505.
Okay, but it also
reference to privacy.
Just go with me, okay? That code section says, does it not, no party or witness shall be required to testify as to any matter which may incriminate or tend to incriminate such party or witness, or which shall tend to bring infamy, disgrace, or public contempt upon such party or witness. You'd agree with that, right?
I'm not reading it.
I'm sorry?
I'm not reading it. I don't have it in front of me.
If I may.
We can, I can take judicial notice that is what the rule says if you want to ask him any follow-up questions.
Okay, thank you. You are not claiming that your answer to number 4, interrogatory number 4, on January 25th, 2024 incriminates you, that is, as in Fifth Amendment privilege, right?
That's correct.
You're claiming the second part, that it would bring infamy, disgrace, or public contempt, correct?
I'm going to object to that. I don't think that's the full thing, but and also the witness doesn't have it in front of him, so I don't know how to respond to that. He's heard several times privacy is why he ends up that statutory.
Overruled.
I'm claiming privacy.
The privilege that you make reference to is to infamy, disgrace, or public contempt.
Upon the witness, right? Or party. That's the section that you were relying on, correct?
If that's what it says, yes, sir.
Okay, look. I could show you, but I think the court has already indicated he can take judicial notice of the statute. So you assume that what I'm telling you is accurate, okay?
Yes, sir.
Okay. How would an answer of none bring infamy, disgrace, or public contempt upon you?
So, as I explained in direct of Mr. Roman's counsel, the minute she elected to intervene into my divorce proceeding, I then started to understand the bigger picture, which was that all the attorneys in the election interference case were colluding with Joycelyn's divorce lawyer, and because of that, I said, privacy. I don't want my divorce proceeding to bleed into this criminal proceeding. I just...
Oh! Oh! Wow! That's interesting. That's why he said privacy, and oh man. So, I gotta say, Trump lawyers are good, and his wife is out for blood, and she has no problems throwing him under the bus. Well, that's not funny, but you know.
Didn't want that.
So you raised a privilege, if I understand, that indicated that your answer would bring infamy, disgrace, or public contempt upon you, right?
Your Honor, I'm going to object to the relevance of this being asked and answered several times.
Mr. Seda, where are we heading with this?
I think I can finish that up by saying you didn't say none again. You asserted a privilege, correct?
That's correct.
Okay. And you did the same thing, did you not, with number 5?
That's correct.
That is, you didn't say none again, right?
Correct.
Okay. Is the answer to the interrogatory number 4, as you have it in front of you, is the answer none? Is that the truth?
The answer is, to that interrogatory, is as I placed it at the time I responded, sir.
I'm
That's
asking
the
you
answer.
now, is the answer to that interrogatory
The answer
none?
The answer is still privilege.
All right. So he's apparently electing to apply the same privilege, Mr. Sada, to that exact same question.
And I have a case which indicates that we can get beyond that if the court deems that appropriate.
And to what end? To what end? Where?
That the privilege actually does not apply and he must answer the question.
And where does that get us? Even if he answers the question, hasn't he already kind of said everything he has to say about the nature of the relationship, how long it lasted, when it ended?
No, I think it would prove. I think if he is forced or compelled to answer the question, he will either answer it falsely by saying none, or he answers it truthfully by saying yes, and then telling us what it is. That's what I believe. That's why I'm asking.
But the interrogatory you're referring to, though, the question contained there.
Two interrogatories, yes, sir.
It's the entertaining one. It's whether there were other relationships, right?
With the specific language that's in the interrogatories.
Sure. Haven't you already covered that in all the other questions that we've had so far?
Yeah, but we have, but again, the court could, if I could require or compel his answer would still be none, then we would know whether or not he was telling the truth now. If the answer is no, then obviously there was a time in the past where he was not. It simply requires him to now answer under oath
What he refused to answer and claimed, and I might suggest, it's a bogus privilege.
and that you can pierce that privilege because it's a material fact in connection with this case. Again, it's a call that Your Honor makes. I have the case law that says you can do that, but it's your discretion.
Ms. Cross?
Your Honor, Mr. Williams on the stand now for several hours. He's been asked and answered very personal questions, I believe cover the issues. Mr. Sadal is making an argument, and this is probably an argument to make for the, later to the court and not a question to propound.
So as I see it, the only relevance these interrogatories have to this case really whatsoever would be as either prior inconsistent or consistent statements. And to that end, I think the question has been put to him again and again and again. He's answered how he believes he felt his answer should be and why he answered a certain way. And as it goes to credibility, I think at this point we're arguing weight, and I don't really see the value in pushing this issue further. So,
All right. Well, just for the record, the case that I was going to refer to.
The judge is like, hey, look, you've been down this road over and over and over again. There's no value. Move it on. Move it on. Oh, this is going to get good. Oh, my goodness. The level of going on.
Is State versus Wakefield at 324 Georgia Appeal 587. And specifically, let's see, it would be 590, in which they talk about this specific privilege. This is a 2013 case. And then they footnote to footnote 3. And footnote 3 says, there are times when the materiality of the evidence outweighs the testimonial privilege. And it goes and explains what that is. That's what I'm bringing up.
And I see what you're saying, that we could say that you need to answer the question regardless of the privilege you asserted. At this point, though, I think we've covered that ground and we're ready to move on.
Okay. Based on that, I have nothing else. Thank you.
Okay. Mr. McCulloch, anything on behalf of Mr. Floyd? Moving through defense counsel.
Oh, I'm sorry.
No, I'm looking behind you. Mr. McCulloch, on behalf of Mr. Floyd. He's elbowing you, sir. Okay.
All right. I've been at this for about an hour. An hour and 20 minutes. So I'm going to pick this up tomorrow. I'm going to do it in bits and pieces because I could be here 5 hours and I don't want to do that. But I got to say, man, oh man, these lawyers picked on the small little things. And I peeped something. Okay, how can I say this? The way we use English, they use it differently. It's more of a technical. You're going to say the way they use English, Laura? What the heck are you talking about? Well, it's very structured, and he kept on saying, define it. What do you mean by that? And then he will come and give a meaning. Now I'm like, wait a minute, I know that word as this right here, but the definitions are different when it comes to court of law. But on that note, what do you think? Do you think that Trump's lawyers are making ground? Or do you think Nate, with Fani all the way in the back listening? Oh, she was listening. Her in the back listening. Do you think that Trump's side made some headwaves? Or do you think Fani Willis' side maintained status quo? We're not giving you anything. I don't know. I'm not a lawyer, but I'm just not. But on that note, see you tomorrow with more of this trial. Bye-bye.